Now we'll discuss question number 52, which asks define a lease. What are the essential elements of lease? The very answer of definition of lease as we found under section 105 of the Transfer of Property Act. So a transferor is considered as the lessor and the transferee is considered as the lessee. So, as defined under Section 105 of Transfer of Property Act, a lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee who accepts the transfer on such terms. The transferor is called the lessor. The transferee is called the lessee. The price is called the premium, and the money, share, service, or other things to be surrendered is called the rent. And now we'll discuss the essential elements, and the essential elements are five in number. The first one, the parties; the second one, the immovable property; and the third one, there is a partial transfer; the fourth one, there is a period of term for such lease; and the fifth one, the consideration or rent. So, the first one, the parties, the lessor must be competent to contract. The lessee must also be competent to contract, because the lease involves the fulfillment of certain covenant, for example, to pay rent. Hence, a minor cannot be a lessee. And regarding partial transfer, it is a transfer of a right of enjoyment, that is, right of possession and use of the property. It is not absolute transfer of all rights. Some rights remain with the lessor. The lessor retains an interest which is called a reversion. The rights and interest transferred is called leasehold. A lessee gets an interest in the property which remains with him according to the terms of the lease, and which is not defeated by any subsequent sale or transfer by the lessor. The word demise is also used to denote transfer by a lease. And now we'll discuss regarding the term or period. The period for which the lease is to ensure must be definite. It must have a certain beginning and certain end. If an interest is granted which, though of indefinite duration at first, is capable of being rendered definite by the happening of some event or by act of parties, it is a valid lease. For example, a lease for the duration of the year, or a tenancy from year to year. So, where according to the terms of the lease deed, the lessor had a right to enter into possession of the leasehold premises if the rent was not paid by the lessee for 3 consecutive months, and the lessor had not paid the rent for about 6 years. before filing up the suit, and thus the lease stood terminated. The full rights in the leasehold property, including the right to possession, would be reverted to the lessor. The lessor, having enforced his right of forfeiture, has every right to take possession of the disputed premises, and his possession could not be termed either illegal or unlawful, and the defaulting lessee whose lease already stood terminated on breach of express covenants of the lease deed could not claim restoration of possession for the unexpired lease period, as it was held by the Punjab and Haryana High Court in 1992 in the leading case Saraswati Gate versus Dhanpal Singh. So, in that connection, we would like to discuss another important leading case decided by the Allahabad High Court in 2007, and that is Shiv Kumar versus Chote Lal, where the Allahabad High Court, the question was whether an unregistered documents more than 30 years old could be presumed under Section 90 of the Evidence Act to have been executed and attested. The court held yes, in the light of proved facts of continuous possession and payment of rent. In proof thereof, the defendant claimed ownership on the basis of sale deed. They could not prove the area and boundary in sale deed did not tally with the area of their predecessors in title in gift deed. The plaintiffs were held entitled to possession, and unregistered lease deed could be looked into for proving possession. So, also in the very case that relating to the essential elements of lease as relating to consideration or rent. The consideration is another essential elements of a lease. So the consideration is either premium or rent or premium plus rent. Premium is the sum paid or promised to be paid in lump sum. Money, a share of crop, service, or anything of value to be given or rendered periodically is rent. So, this should be the correct and appropriate answer relating to this question. Define at least what are the essential elements of a lease. So now we'll discuss question number 53, that is distinguish a lease from a license, and in regards to that we'll discuss the provisions of Section 105 of Transfer of Property Act, also Section 52 of Easements Act, and also some leading cases. So, lease had been defined in Section 105 as transfer of right to enjoy an immovable property made for a certain time, expressed or implied in consideration for a price paid or promised, whereas license has been defined under Section 52 of the Easements Act as a grant to another person the right to do or continue to do in or upon the immovable property of the grantor something which would be in absence of such right be unlawful, and such right does not amount to easement or an interest in the property as it was held by the Patna High Court in the leading case Prakash Shiv versus Bihar State Road Transport Corporation in 1981, while differentiating between lease and license and also by defining the very scope and jurisdiction of license as provided under section 52 of the Easements Act. So the very distinction that we found in between lease and license. So the first one, that in a lease there is transfer of an interest, but in case of license there is no transfer of an interest. So in a lease there is a transfer of an interest in immovable property, whereas in case of license there is no transfer of interest. Although the licensee acquires a right to do or continue to do in or upon the movable property of the grantor something which would, in the absence of such right, be unlawful. And the second difference that we found, in case of lease, it is right in rem, but in case of license, it is right in personam. So, the right of a lease is a right in rem. It can be enforced against the grantor as well as a third person. The right of a licensee is a right in personam. And now we'll go to the third difference, that in case of lease there is exclusive possession, but in case of license there is no question of exclusive possession. A lease passes the right to exclusive possession. A license does not carry exclusive possession of the land to which it relates, but merely authorizes the licensee to do something on that land which he would otherwise have no right to do. In a lease, the owner parts altogether with the possession of the land, and in a license he does not. A familiar illustration in the case of Ledger, who, despite the fact that he has the right to sole possession of his rooms, is a mere licensee because the owner remains in control and management of the house as a whole. And now we'll go to the fourth difference that we found in between these two. While in lease the immovable property is assignable, but in case of license it is not assignable. So a license is not assignable, while a leasehold can be transferred by the lessee to the sublessee. And now we'll go to the fifth difference that we found. In case of lease, there is the right to sue the strangers, but in case of license, there is no title to sue the strangers. So, a lease is not a mere contract, but envisages and transfers an interest in the property, creating a right in favor of the lessee. In license, there is no transfer of interest as it was held in the important leading case Chandar Lal versus Municipal Corporation of Delhi by the Delhi High Court in 1978. And now we'll discuss the sixth important difference that we found in case of this. There must be a notice to quit, but in case of license, there is no notice to quit is required. And as regarding the seventh, that we found a license is not entitled to notice to quit before eviction. And in that regard, we would like to discuss one important English leading case, and that is Errington versus Errington. In 1952, it was observed that at one time it was brought that the test of exclusive possession was infallible, and if a person was given an exclusive possession of premises, it would exclusively establish that he was a lessee. But there was a change, and the recent trend of judicial opinion is reflected while Lord Denning in this important leading case, Errington versus Errington in 1952, as follows. The result of all the cases is that although a person who is let into exclusive possession is prima facie to be considered a tenant, nevertheless he will not be held to be so if the circumstances negative any intention to create a tenancy. And in that connection, we would like to discuss the important ruling of our Supreme Court in 1956 in the leading case Associated Hotels of India versus R.N. Kapoor, where it was quoted with approval by the Supreme Court. Lord Denning's observation as under to ascertain whether a document creates a license or a lease, the substance of the document must be preferred to the form. Secondly, the real test is the intention of the parties. And the third one is if the document creates an interest in the property, it is a lease. But if it is only permits another to make use of the property of which the legal possession continues with the owner, it is a license. And fourthly, if under the document a party gets exclusive possession of the property, prima facie is considered to be a tenant. And in another important leading case that we will discuss, and that is Madan Mohan Kukreti versus Gita Bhavan in 2007, the Uttaranchal High Court expressed that the accommodation was given to employee to facilitate him to discharge his functions. The facility was till the period of service. The question was whether this constituted leisure license, particularly in view of the fact that a definite amount was deducted from the salary of the employee for the accommodation given to and enjoyed by him. The court held it was merely a license. He had no right to return premises after termination of his service by the employer. And in this connection, we would like to discuss the last most important leading case, that is A. Money versus E.O. Panchayat in 2007, decided by the Madras High Court, where the question was whether permission to run shops on roadside is lease or license. In this case, tenders were invited by the executive authority of the panchayat to put up temporary shops on street margins and roadsides during tourist season in Kanyakumari. Possession of street and road remained in Panchayat. The court held it was a license. So these are the important leading cases relating to differentiating a lease from a license as provided under section 105 of Transfer of Property Act and also regarding license as provided under section 52 of Easements Act, and we have differentiated all the six important differences that we found in between lease and license, and as we think this would be the very correct and appropriate answer to question number 53, and that is Jishnu is a lease from a license. So in our upcoming video we'll discuss question number 54, and that is how are leases met, what is the extent of their duration, and the requisites of a valid notice to quit.